Times now has accessed the Supreme Court order in the Adani-Hindenburg matter today. That order came today, and it also says the top court cannot treat Hindenburg report as a true state of affairs or credible. Coming back to you, Harish, one more and Aditi will in fact take us through the details. But before that, let me go back once again to Harish, because point number I, Harish, is very important. It says, and I quote, SEBI and investigative agencies of the union government shall probe into whether the loss suffered by Indian investors due to the conduct of Hindenburg Research and any other entities in taking short positions involved any infraction of the law, and if so, suitable action shall be taken. So apart from the two pending cases which will be probed by SEBI, the matter does not end there. It will also be looked into the actions of Hindenburg and the kind of losses that had resulted in on the part of investors following the publication of that report.
Yes, so that's right, Siddharth. This will be one of the key aspects which the SEBI will look into. And now already it has said that it has identified, SEBI had already said that on the basis of the report submitted by the Supreme Court Committee, the Supreme Court Committee and SEBI has agreed that there were around a dozen cases of short selling. And even this judgment also means that, as you rightly said, even the role of Hindenburg that will be probed as far as short selling is concerned. So
right.
Not only the Adani group, which it also indicates that out of the 24, one of the case may be this, and already the Solicitor General Tushar Mehta had given strong hints as far as this angle is concerned during the hearing. Back to you.
All right, Harish, thanks a lot for taking us through those details. Aditi, coming to you now. You have the order copy with you. Please take us through the operative portions.
Well, exactly. And Siddharth, let's quickly take a look at the operative portions that are the power of this court, which the Supreme Court said to enter the regulatory domain of SEBI in framing delegated legislation is limited. The court must refrain from substituting its own wisdom over the regulatory policies of SEBI. The scope of judicial review when examining a policy framed by a specialized regulator is to scrutinize whether it violates fundamental rights, any provision of the Constitution, any statutory provision, or is manifestly arbitrary. No valid grounds, therefore, this is what the Supreme Court is noting in its judgment copy. They state that no valid ground have been raised for this court to direct SEBI to revoke its amendments to the FPI regulations and LODR regulations, which were made in exercise of its delegated legislative power. So these were the main points and highlights of the Supreme Court judgment.